Welcome once again to GN Live. I am Gilbert Nyambavam. Now, today we are unpacking a major legal development. I'm not really sure why it has not been reported elsewhere, but that's why we are here. The litigation involves Zimbabwe. It involves international investment law, and it involves more than 320 million US dollars in arbitration awards, which a United States federal court has now ruled can be enforced against Zimbabwe. This decision marks another significant chapter in a dispute that has stretched over 2 decades and centers on Zimbabwe's land reforms. Stay with me, because after this break, I'm going to explain to you what the court in Washington, D.C. has said and what exactly it means for Zimbabwe. Join me after this break. Welcome back, and thank you ever so much for the support you give to this program. Now, we said this is a story that we have covered before on this program. So what is the new development? Well, a federal judge in Washington, D.C., Judge Amit Mehta, has ruled that 2 arbitration awards which were issued by the International Center for the Settlement of Investment Disputes, which is better known as ICSID, and is a member of the World Bank Group. The court has ruled that those awards can now be enforced against Zimbabwe. The awards, which are worth more than 320 million US dollars before interest and other costs, were made in favor of the von Pezold family, who are Swiss and German investors, and 2 plantation companies operating in Zimbabwe, that is Border Timbers and its subsidiary, which is known as Hangani Development Company. The investors had argued that Zimbabwe damaged and partially expropriated their plantations during the country's land reform program. Now, this is a dispute which dates back to the early 2000s, and as many of you would remember. The properties involved included 3 large plantations in the Eastern Highlands, with operations in tobacco farming, forestry, coffee, bananas, maize, macadamias, avocados, as well as timber production. Now, following constitutional changes in Zimbabwe around 2005, the government compulsorily acquired parts of these estates as part of the country's land reform program. The investors, the von Pezold family, claimed that the acquisitions violated bilateral investment agreements or treaties that existed at the time between Zimbabwe, Germany, and Switzerland. Those agreements and those treaties provided protections for foreign investors such as the von Pezold family, and allowed disputes which arose in the context of those investments to be resolved through international arbitration. In other words, the investment protection treaties that Zimbabwe signed between Switzerland and Germany allowed for this dispute to be referred to platforms and institutions like ICSID. Now, in 2015, ICSID tribunals ruled in favor of the investors. The von Pezold family was awarded approximately 195 million US dollars. Border Timbers, on their part, received around 124 million US dollars, plus an additional 1 million US dollars in what they described as moral damages, together with interest, legal costs, and expenses. Zimbabwe later sought to have their awards annulled, but those applications were rejected in 2018. Now, it is important at this stage to understand what the court in Washington, D.C. has actually decided. This was not a new trial about whether or not Zimbabwe was right or wrong. Instead, the court was looking at a very specific question. It was considering whether the existing international arbitration awards from ICSID should be recognized and enforced in the United States. In other words, once you've secured arbitration awards at ICSID, you now need to take them to some jurisdiction where they should first be recognized before you can look at execution, which are 2 different legal concepts altogether. Stay with me, because after the break, I'm going to look at the arguments which were raised by Zimbabwe and why the court tossed him out. Join me after this break. Now, Zimbabwe's lawyers presented several arguments opposing enforcement. First of all, the lawyers argued that under Zimbabwean law, the awards could not be executed against the state. However, the judge made an important legal distinction. He said enforcement and execution are two different legal concepts. Enforcement simply means converting an international arbitration award, in this case the ICSID awards, into a local US court judgment. Execution, on the other hand, involves identifying and seizing assets in order to satisfy that judgment. According to the Washington DC court, the case before it was only about enforcement, not about attaching Zimbabwean assets in the US. Therefore, Zimbabwe's arguments about immunity from execution were not relevant at this particular stage. So that argument opposing enforcement fell away. Zimbabwe's lawyers also argued that the investors, the von Pezold family and the companies, had continued operating on the plantations, and therefore any profits they earned from those operations should be used to reduce or offset the amount owed in terms of the ICSID arbitration. But the judge rejected that argument as well. He said the arbitration tribunal had already determined the amount payable and had not made that award conditional on whether or not the investors continued operating on the properties. The court also noted that Zimbabwe failed to provide sufficient evidence showing the value of the alleged offset. In other words, if you're claiming that the companies and the investors continued to operate on the properties, and therefore the money that was earned should be used to offset the award, you should be able to say how much. So for that reason, that particular argument also failed. Another point which was raised by Zimbabwe's lawyers concerned post-award interest. Again, the judge sided with the investors. I mean, his position was straightforward. The court said that if the arbitration tribunal awarded interest, then the US courts must enforce the award as written by the ICSID tribunal. So the question is, having ruled that way in favor of the investors and against Zimbabwe, what happens next? Stay with me. We explain that after this short break. Welcome back. And that question. So what happens next? Well, the judge instructed both parties to submit a draft final judgment. Once that judgment is entered, the investors could begin looking for Zimbabwean commercial assets in jurisdictions where enforcement is legally possible. However, this does not mean Zimbabwean assets will automatically be seized. There is no immediate risk. Any attempt to attach assets would require separate legal proceedings and would likely involve questions of sovereign immunity under the laws of the country where those assets are located. So there's no immediate risk to Zimbabwean assets around the world. But why does this particular case matter? The case is significant for a number of reasons. First of all, it reinforces the strength of international investment arbitration systems and demonstrates that ICSID awards can be enforced in national courts around the world. Remember too that the same case was before the Supreme Court, the top courts, the High Court and the Supreme Court in the UK, where Zimbabwe unsuccessfully argued to be accepted, citing sovereign immunity. Secondly, this particular case and this particular ruling highlights the long-term financial consequences that can arise from investment disputes between government and foreign investors. And finally, for Zimbabwe, it represents another legal headroom in resolving outstanding claims linked to the country's land reform program. Claims that continue to attract international attention more than 25 years after the original events occurred. Now, as the case moves into the enforcement phase, attention will likely shift to whether the investors can successfully recover any money and what implications this could have for Zimbabwe's international financial obligations, investment climate, and the investment attraction prospects. For our part, and on your behalf, we will continue following the developments as they unfold. Thank you for watching GN Live. If you found this report and this analysis useful, don't forget to share, to subscribe, and let us know your thoughts in the comments below. My name is Gilbert Nyambavum. Until next time, goodbye.